So, as with any good lawyer presentation, you have a disclaimer. So, everything I'm going to say is educational in nature and not legal advice. Next. So, as I mentioned, I'm a partner with the firm and thoroughly enjoy what I'm going to do with you today. Next. We're going to have 5 objectives that we want to accomplish during the presentation today. First, I want to give you a quick, and you're going to be drinking out of a fire hose with me today, but you're going to get copies of all the slides as well. A section-by-section walkthrough of the regulations. I want to talk about the issue of evidence and creating of evidence and what you need to do when you as an employer make a clearinghouse report and why it is so critical that you understand what evidence is and what evidence is not, which is called hearsay. We're going to talk about actual knowledge, and I'll explain what that means. 4, we're going to talk about 9 compliance landmines that we have spotted in the regulations and then how to diffuse those. And then we're going to talk about policy update requirements of the regulation. Every DOT regulated policy, Federal Motor Carrier policy, will be out of date as of January 6, 2020, if not updated. And I'll talk to you about how we're working with employment screening services to help you do that. Next. The clearinghouse is going to affect everyone in this particular industry. So it's going to affect every employer of a CDL driver. It's going to affect service agents. Now, service agents are like substance abuse professionals, medical review officers, collectors, any third-party administrators, anybody in this industry. It affects every one of them. And it's going to affect also probably Amazon Web Services. And I say that because they're a cloud storage provider, and they're going to have clearinghouse information in the cloud. So they don't know it yet, but they are. And then you affects every CDL driver across the country, no exceptions. Next. The historical overview is what's out there now is not working. So in Congress passed and the President signed on July 6, 2012, the Moving Ahead for Progress for the 21st Century Act. So that mandated that the DOT adopt new regulations on the clearinghouse. So why do we need the clearinghouse next? We need the clearinghouse because of incidents exactly like what's on your screen. So in Springfield, Massachusetts, a CDL driver in a commercial motor vehicle collided with seven cyclists who were part of what's called marine cycling group. There are actually 10 in the group. He killed 7 of them. And the bad thing is the information starts coming out about a troubled arrest record with drug charges, traffic incidents spanning 6 different states. Next. And so here he is. And that is the look of a guilty person. Next. And how could he keep driving a CDL with this checkered past of his? What happened is the Massachusetts Registry of Motor Vehicles admitted that its license should have been revoked following a drunk driving incident on May 11th in Connecticut. But the informal channel system that goes between these different states and the employers wasn't working. So what happened, and actually the official for the state of Massachusetts resigned over this entire incident, and if we had the clearinghouse in May or June, because this guy was only hired 3 days before, and I want to call it a homicide. It's not an accident. Before this homicide occurred. Next. So as we're looking at if we're looking at the regulations and the way they break down, there's a new 700 series within 382. And you see it covers every facet. We're going to in detail kind of walk through these, but it's going to cover all of these issues on the clearinghouse. So think of the clearinghouse as a huge data collection website set up by the federal government where all of this information concerning drug and alcohol violations by drivers is housed. And it's a compilation of data not only from the states about CDL violations, but also from every employer that contributes data into the system. Next. And as you can see, there's a lot to this. So what I'm going to do is give you the highlights of all of those sections you're looking at right now on the screen, and we're going to kind of get them down into manageable bite-sized bits for you to understand. Next. So as I mentioned earlier, the current system is just not working. It's been a driver self-reporting positive system. And then you have to query the past employers that the driver voluntarily gives you the names of, and then you got to get information back. Again, it is not working. So this is a huge reason why Congress mandated that this system change and be upgraded. Next. This is all about safer driving, safer highways across the nation. It will give you real-time access to reported violation information for authorized users. It'll be easier for the employer to meet the pre-employment investigation and reporting obligations. It'll be more difficult for drivers to conceal drug and alcohol violations from employers. And lastly, it'll give more insight by the Department of Transportation, FMCSA division, into employer compliance with drug and alcohol testing. So there clearly will be a big brother watching how that you're in compliance. Next. So the final rule was actually issued on December 5, 2016. Most people basically sat on their hands from this for the last 2.5 years, and all of a sudden, shazam, they're all paying attention to it now because it goes live on January 6, 2020. So it's mandated compliance. The link to the reg is at the very bottom of that. It's 183 pages long. Highly recommend that whoever in your organization needs to understand this, prints this off, puts it in a notebook, starts saving stuff. And we're gonna share stuff with you at the end of this, including the presentation. And I've got 3 other resources that will help get you a jump start on compliance. Next, on the timeline, you will see December 5, the rule published. Information phase has been going on for about the last 6, 8 months. I actually co-presented with the FMCSA in Detroit about 6 weeks ago. And then interestingly, at the Substance Use Program Administrators Conference in Philadelphia, I was able to have a training class for that group. We had a room built for probably 40. We had 45 in it. I had 4 federal regulators who'd helped draft these regulations in the room answering questions. So I was the moderator and the presenter all in one. So it's fascinating. So I've actually updated this presentation you're watching with me today based on some of the new information they shared during our meeting. And you'll see the January 6, 2023 date. So as far as the background checks that you're going to do, you're going to continue to have to do PACR background checks for this 3-year period of time, and then it blends out as of January 6, 2023. Next, the biggest shock really came who this applied to. So it applies to every CDL driver. It applies to every CDL driver that works for a municipality, a county, or a state. Huge expansion by the DOT of who is covered by this regulation. And most counties and cities are scrambling to try to figure out how they're going to comply. Next. So here's the language that they inserted into what's called 382.103 of the Federal Motor Carrier Safety Regulations. The yellow language about traffic, transportation, which affects trade traffic or transportation. So they basically, with about 5 words, expanded the coverage to literally millions of additional employees that really weren't thought to be covered in the past by the FMCSA regulations. Next. So the heart of the system is the query system. That means that once every 365 days, you're going to have to run an annual query on every one of your CDL drivers. One of the resources that we're going to share with you in the box account that you'll have access to is actually a prepared spreadsheet example for you. And also I've given you the language out of the clearinghouse on how to fill that out. So one of the things you're going to need to start doing is to populate an Excel sheet with all your CDL drivers and with the information that'll be on the spreadsheet. And I've given you the state codes and everything else that came off of the Clearinghouse website to understand how to do it. So you got to do this annual verification, and you're just doing it to find out, is there information in the database concerning my driver? If there is information in the database, that is not good news for your driver. That means there's some kind of violation information in the database that has not been resolved. So again, if you get a hit on your annual query, think of an Excel spreadsheet that you upload, and then it queries it probably in a matter of seconds and then gives you a response. If you get a hit, then you have to do what's called a pre-employment screening, even if they're currently employed, or a full query. They call it kind of two different phrases, but you've got to do a full query on any new hire, and then you've got to do a full query if you get a hit. Next. The purposes of the query are, again, to make sure that there's nobody with drug and alcohol testing violations that's working for a CDL employer, an FMCSA governed employer, that's not been through the SAP, substance use program process, and not been through group testing that says that they're cleared to go back to work. So there's two different query types, the way those work. Next. The queries, this is one of the documents the FMCSA published about explaining the queries. So you see the pre-employment is called a full query, access full details of the violation, specific consent. Now, the way you get specific consent for this is you actually have to, the driver has to consent within the electronic database. So this is not a consent that you get in writing. This is a consent that you get once the query process is begun. An annual verification you can actually get, they only released this information about a month ago, you can actually get a signed authorization to do query for the duration of their employment on an annual limited query basis. So that's extremely helpful. And then they've issued some language. We drafted policy form toolkits as part of our help to help clients with compliance that have 26 forms in them. One of them is a limited query consent form. One of the things you want to do is to make sure you've got one that complies with the particular regulations and follows that. Next, so if the driver gets a consent request, they can either say, I consent, or I do not consent. If they go, I do not consent, you got to take them off the road. You cannot continue to use them at the point that they refuse a consent request. So again, that's a big deal, but the consent will have to happen. Most likely they'll get a notice on their phone, on their cell phone, and ask, do you consent? So they would have filled out an application, and then the driver and then the company runs the query. Next, there's a lot of reporting obligations built into the regulations. As you can see from this spreadsheet, you've got drivers have an obligation to interact with the database, employers of drivers, certified third-party administrators, so this would be like an employment screening services organization, and then medical review officers of the MRO, and then the SAP, substance use professionals. You can see everybody has different levels of compliance and different levels of reporting that they have to. So they are mandated by regulation to comply with this process that you're seeing on the screen in front of you. Next, so the medical review officer is probably the heart of the system. If a medical review officer gets a verified positive, that means verified positive, they've either interviewed the driver or attempted to interview the driver, they find an adulterated substituted drug test, they got to make it, they got to make the report directly to the database of that result. And if there's a refusal, the only refusal that an MRO typically reports is what's called a shy bladder refusal, when they don't have a medical excuse. All the other refusal reportings are going to be in the employer's hands. So as a wise counsel, let me kind of, you see my potential landmine down here? So one of the things you need to kind of do is take a deep breath if an MRO is going to make a report and going to call you and say, I got a verified positive. I say that because there are a number of kind of appeal processes, both that have been existing, like a split specimen, or there's some new ones in the regs we'll talk about some more. But I say take a deep breath because it may be that there's going to be a change in the MRO result. And you can see the MRO has to make the change report within 1 business day once he gets the new information or she gets the new information. Say, for instance, a pharmacy maybe was closed the day the MRO tried to make a call to verify a prescription, and he went on and made the report of a positive drug test, but there was prescription, and the prescription information would have changed the result. He talks to the pharmacist, he finds out, oh, they got a prescription, he changes the result. So he has 1 day to go back in and change that. I highly recommend that you take a deep breath, that you suspend the employee on unpaid basis pending final investigation, that you give about 10 days for the process to kind of blend out and end up so you can find out. The regulations really are, while they're compliance with drug and alcohol testing, they really implicate a lot of HR issues. So the DOT will never tell you fire an employee. But many of you, when you get a positive drug test result, are going to fire the employee. I'm just saying that take a deep breath, wait that 10 days, and then I'll show you some other risk reduction techniques as well. Next. So you've got to retain records. If you're going to get a request for records to be shared with anybody else, you've got to make sure you have authorization from the driver to do it. There's a whole section of the Part 40 series and the 300s that I'll talk about the different consents. Next. As an employer, one of the main reporting obligations is an alcohol, what we used to call an alcohol positive, but the DOT changed the way we worded that. So it's now an alcohol with a test result with an alcohol concentration of 0.04 or greater. So that would be considered, in the old vernacular, a positive alcohol. You've also got 12 different types of negatives that you got to report if you're the employer. So these are things like refusing the site, interfering with the drug test, all kinds of, they're likely 12 different grounds in Part 40.191. And then you've got to report a successful completion of the SAPS follow-up testing. So again, there's a lot of reporting. In fact, the employer has the most reporting obligations of all of the regulations. So again, when we prepared and our helping employers, we actually came up with a reporting form for the clearinghouse that covered every one of the employer reporting obligations, but also had a driver response at the bottom. The reason I did that is because in employment law, the devil you know is always better than the devil you don't. So that means that I want to know if an employee says they got a legitimate excuse. I actually want to hear it. I want to hear it before I report it to the clearinghouse, because maybe I can change, maybe that employee can change my mind. Here's, for instance, the employee directed to go to a collection site. On the way to the collection site, he gets a call from his wife that his dad just got admitted to the emergency room. So rather than go to the collection site as directed, he goes to the ER at the hospital, and he's seeing his dad. So at that point, maybe the employer gets wind of it, maybe doesn't, but the employer is the one that's going to make a decision. Is that a refusal, or is that an excusable event? So again, that kind of flexibility in your reporting is helpful. But if you have a response document you're going to present to the employee, I want you to hear that statement and that excuse before you make the report up, and you'll see why. All right, next. So there are a lot of reporting obligations in the employer. I told you the first one's the alcohol, the adulterated substituted drug testing, next. And these are under 382.217. But refusal to submit is the C category. The driver's use of alcohol prior to post-accident drug testing in violation of 382.209. The employer has actual knowledge. I'm going to save that discussion because actual knowledge is very confusing, and we'll talk about what it's not. If they used alcohol prior to performing safety-sensitive functions within 4 hours of performing it, or used a controlled substance, we'll talk about what actual knowledge is, and again, what it's not. Next, so any violation information in Clearinghouse, you have got to save for 5 years. So if you ever get an audit or an inspector, he's going to be asking you, show me your Clearinghouse violation report information. Next, and if they want access to your facilities, you have to say yes. So this could be the Department of Transportation. This could be any of the federal agencies that were investigating a crash and things like that. So again, just know that whatever they claim is Clearinghouse information, you've got to share next. And then, as you'll see, the National Transportation Safety Board has clear rights to request information from you as well. So I told you what a positive alcohol was. Let me show you what a negative alcohol test result. So rather than using negative return to duty language, it used the language I have in red there that says an alcohol test with an alcohol concentration of less than 0.02. So those are two really defined issues you need to understand. The other big issue is how are you identifying your drivers in like a random testing system? I highly recommend that you do not use Social Security numbers anymore for any of the driver identification, that you use the CDL number and the state of issue. So again, the CDL number is stated. Thank you for moving that slide without me asking. You noticed it was the next one. All right. Next, if the driver is working for two different CDL employers at the same time, say they're working as a school bus driver for the county on the weekday, and on the weekend they're hauling cement for somebody. If they have a positive test result working for one of those employers, under these new regulations, under 382.415, they have an obligation to tell the other employer, not the one that's testing them, but the other employer. So let's say it's let's say the cement company is doing the random alcohol test, and you get positive random alcohol. They have an obligation within 1 business day to then report that to their school bus employer. And if they don't, they can have a fine up to $3,750, and probably some other bad things are going to happen to them as well. So before the end of the next business day. Next. So let's talk about the thorny subject of actual knowledge. And I say it's thorny because when I had these regulators in the room, we had disagreement between them as to what actual knowledge was. Let me tell you what it's not. So if somebody gets a DUI after hours driving their own personal vehicle, there is no actual knowledge. Okay, that's not what this is meant to cover. It's meant to cover actual knowledge when you see them drinking alcohol during hours that are supposed to be either immediately before, immediately after, or during performance of CDL functions. Okay, or they're smoking a marijuana cigarette or running a line of coke or something like that during those same times of working hours. So that's clearly is actual knowledge. If you find beer cans in the floor of the truck when they come in, but you didn't witness them drinking, if you find a marijuana cigarette in the truck, but you didn't witness smoking, most of the regulators would say that's not actual knowledge. But I'm just telling you, it is. So I've given you what it's not, and I've given you what it is. I will tell you there's gray matter in between the two of those. So even regulators have a double time defining. So we created an actual knowledge form in the toolkit that has attached to it the back of the regulations. But again, a lot of times when I get sticky questions, I actually contact the regulators and ask them. They know who I am, and I do it anonymously, so they're not identifying me with one particular client to do that. Next, there is a pull-down screen that they're creating, and this is kind of what it's going to look like. It's going to have drug violation, alcohol, types of refusals, actual knowledge, when you obtain the knowledge, the state the violation, the detailed. Actually, they want you to upload all kinds of stuff. So if you get some kind of violation, either refusal or actual knowledge violation, they want you to take pictures or videos. They want you to give them as much evidence as possible to get that bad driver off the road and help them. So the pull-down menu has plenty of room to upload, attach, and send. Now, when you're working with a third-party administrator like Employment Screening Services, you have options here. If you want to assign them the responsibility for making your reports to the clearinghouse, doing all your queries, I'm sure that Megan and Todd and their crowd would be able to help do all those functions for you. But you will also have access to the clearinghouse database at the same time. You will grant them access as a certified TPA, and that's also enrolled in the clearinghouse, and they can handle these functions. But again, you'll have access, and you can actually make these reports if you want to as well. The big issue is making sure you understand the issue of evidence, and we're going to hit that just a little bit more. All right, next. When you register in the clearinghouse, so it's mandated that every employer of a CDL register in the clearinghouse, and you've got to do that by January 6, 2020. It's not hard to do. This is the information you'll need: the company name, U.S. DOT number. Everything in the system tracks by your U.S. DOT number. They really wasn't used much in the past at all, and most cities and counties never obtained one, so they're having to get them now. Your street address, county, city, zip, and state. But that's what you need to register, and I'll show you the link to register in a second. Next. So if you're a third-party administrator like Employment Screening Services, they can make all these reports. They can run the queries for you. They can advise you on what issues, and they can make sure you've got evidence in place. You're very fortunate to work for somebody that has a Todd on staff there as an attorney, so he kind of understands the evidence issues that I'll share some more with you, and that's extremely helpful. So again, they can make all the reports for you, or you can divide responsibilities between having them do the query and then you deciding I want to make the violation reports myself. Next. So the SAP process, so the only way to get, I hate to use this term, it's kind of a paper cleansing. So if you are a violation, so you've gotten caught with drugs, alcohol, whatever, and you're in violation of the regulations, the only way to clear your name in the database is to go through the SAP process. And so that means that you've got to go through a substance abuse professional interview, face-to-face. They've got to come up with an educational plan for you. They've got to dictate at least 6 tests over 12 months. There's a follow-up test. But that's the only way that you can get back on the road if you're a CDL driver. And I highly recommend that companies look at making sure and have a second chance ability for their employees, just because you are going to run into not having drivers. I hate to say that. We are in a super tight CDL market right now. So highly recommend that you think about being a second chance employer. In the Forms Toolkit that we developed, there is a form. There are actually 2 forms. One of them is the last chance agreement, and one of them is a work continuation agreement. The ways these work is if you have a violation, it's a disciplinary, it's a last chance. If they come forward with a cry for help, it's a work continuation agreement. They're just different in the way that you handle those 2. But again, I tell you to send them to the SAP first to make sure they're a good candidate for rehab before you enter in these agreements. If they're testing positive for 3 drugs at one time, probably not a good candidate for rehab. Involved in criminal mischief at the same time, probably not a good candidate for rehab. So let your professional SAP guide the process. Watchword. So a lot of you have EAPs, Employee Assistance Programs. Highly recommend that you talk to your EAP about them engaging a substance abuse professional that's certified by the DOT. So that way you can use that as your way to get these drivers some help and try to get them back on the road as soon as possible. Next. So this is probably one of the biggest landmines in the system. And you can actually drive a truck through this statement. So the paragraph, this is 382.705, requires that reporting information must be truthful and accurate. Okay, that sounds fine, but look at the next sentence here. FMCSA prohibits anyone from reporting false, okay, I'm good with that, or information that should be known as false or inaccurate. That's the truck you can drive through. So that should be known to be false or inaccurate. Anyone making an inadvertent error should make a correction immediately upon discovery. It's called safe harbor, and anyone violating the provisions of this are subject to criminal and civil penalties. And I'll show you the penalty structure in just a minute. So here's the landmine: an employer with little or no evidence. So Todd and I, when we went to law school, we didn't go to law school at the same time, but we both took evidence classes, and we learned in law school there are certain things that are evidence and certain things that are hearsay. So that's, some of you have watched Perry Mason when you're, some of you millennials hadn't watched any of that stuff, but you understand, you watch enough courtroom TV to understand that some evidence is excluded. Some evidence is not admissible because it's not determined to be reliable. Highly recommend. So when we created forms tool packs, we created certain forms with declarations on the bottom of it. The reason that is so critical is under the United States Code, U.S. Code, you can create a declaration that's introducible in any federal administrative proceeding or federal court, merely by the insertion of one statement at the end. I hereby swear and affirm under penalty of perjury that the above statement is true and correct. And you date it, done this date, and then you sign the bottom. That becomes an admissible declaration, admissible in any administrative or federal court proceeding. So it has the same effect as an affidavit in the federal system. And it's not admissible in the state system, and in the federal system, it is acceptable. So highly recommend that when you're going to create evidence, you do so in a fashion that's acceptable in a federal proceeding. Now, if you've got your alcohol test results, if you've got the alcohol technician's form completed, that's evidence alone. You really don't need another declaration with that one, but you can just scan that one in and report it up with your findings. But those are the kind of things that are evidence to protect you from this this wide hole in here. Okay, so if I'm advising you, and I'm not, this is educational, but if I'm advising you, I'm telling you to create and use this response form in a toolkit like we've got, so that I'm handing it to the driver. You actually have an obligation to serve the driver with whatever you're going to report to the clearinghouse database. So I want you to serve it to the driver and say, here's what we're about to report up to the clearinghouse. And there's a spot here for you to make a response, almost like a final written warning document. Make a response. If you'd like to respond, we'd like to hear from you before we make this report. And it may be that you're going to collect a cell phone number, because you may just be taking a picture of this with a phone and sending it to the driver and asking them to respond to it remotely if you can't hand it to them. But I want you to know what they're going to say. If they say nothing, that is considered a tacit admission. And so when I had the 4 regulators in the room in this meeting in Philadelphia, they were thrilled with this idea of having a response form for the drivers, because otherwise they're going to have to figure out the mess when it comes up to their front door. Next. The next slide is just kind of the reporting obligations back and forth. This is actually the page out of the regs that dealt with those. Next. So most of the time the driver will get notice by probably cell phone or email or personal email address. But in the case that they don't, they'll be mailed whatever information or whatever notice that the FMCSA, and they will use, one of the things to counsel your drivers, they will use the CDL address for the state where their CDL is issued. So if their driver has an old CDL address and is not updated, it is highly important that they update any of their address information in wherever they have secured their CDL driver from. Next, so what about driver access to the database? They have clear, unfettered access to the database at no fee, no charge. So a driver can look in there at any time and ask to see it. Next. Registration actually opened up. I was actually at the office on September the 28th. I was pulling some presentations together and updating some things off the Clearinghouse website, and all of a sudden, Shazam, it was open. It was open for registration, and I could see they had just, this is a Saturday at about 10 o'clock, so I can see they're still uploading and putting new documents on the site at the time. So we alerted all of our clients what was going on, and so they jumped on it. So you can register in the Clearinghouse database now. Now, I'm going to give you a little caution before you do that, and we'll hit that just in a minute. But again, failing to register in a timely manner can be a fine in itself. And then they just announced yesterday, the 5th, that you can purchase Clearinghouse bundles. And I'll talk to you about the query bundles in just a second, but that just came out yesterday on the bundle purchase. So you want to obtain certifications from whoever your service agents are, that they are already part of the Clearinghouse registration. Next, there's a number of things that you can do bad that get you revoked out of the Clearinghouse. So if you misuse information, if you misappropriate access, there's a lot of things that can get you locked out of using the database. Registration is typically going to be good for 5 years. It's going to be canceled for 2 years of inactive status. But again, you can have it revoked for a number of bad acts on behalf of those who have access. So we're going to talk about how do you protect yourself from that next. So here is number 2 biggest landmine of the 9. This is the driver petition system. So if you haven't taken my advice and shown the driver what you're going to report up, gotten their feedback or tacit admission or whatever you got, and you just say, just report it up there. All right. And then the driver says, this is a pack of lies. I was there. I gave a specimen. I did everything they told me to. This is a pack of lies. And I got 3 guys that'll say it's a pack of lies. They can then file a driver petition with the Federal Motor Carrier Safety Administration asking for this blemish on their record to be removed. Okay, they can't challenge the accuracy or validity of an alcohol or a drug test with this system, but they can challenge any of the refusal issues or anything else you as the employer report up to the system. So the driver petition alleging incorrect, misleading information. So again, I'm back to evidence, legal evidence. Whatever you report to the database, make sure that you have a signed declaration or an affidavit or like an alcohol technician's report to support what you're saying. I mean, if you got a picture of the driver with drinking a 5th of Jack Daniels, there's your evidence. If you got other pictures or videos or surveillance pieces, that's your evidence. But just be careful that when you make a report that some lawyer like Todd or I going to ask a question, well, show me your evidence. And you go, well, we just got a phone call from an anonymous source and we acted on that. That is not going to be evidence. So just be careful what you call evidence that will be truly evidence. Next. As I mentioned earlier, the only way to get the papal blessing of getting your name out of the database if you're a CDL driver is to go through the SAP process. So it's in Section O of the Part 40 regulations, and you've got to go through the counseling, you've got to go through the educational, and you've got to do at least 6 and 12. So when we do a last chance agreement, we have the driver pay for the testing. If they're going to go through that, they're going to have some skin in the game. Next, the query system. Okay, how do you get queries and how do you use queries? So again, it opened up yesterday for purchase. If you see there, $1.25 per query. So say I've got 50 drivers and I'm going to run a query on all 50, then that's going to cost 50 times, I can't see the number, $62.50. If you've got 50 drivers, I typically tell you to go ahead and buy a 100 bundle, $125, because you're going to need to use on pre-employments. You can run more than one query a year if you want to. You can run a query every month if you wanted to. You got to run them every 365 days at least at a minimum. So again, they're $1.25. They don't expire. They're not refundable either, but they don't expire. So if you purchase more than you need right now, you still have a bank full of queries in the database. Next, so what about things that'll get you in bad trouble? Okay, landmine. What if you got an unauthorized access? If you got a rogue employee that's starting to get things off of the database and ends up posting on Facebook? All right, that would be a huge, huge regulatory violation. Highly recommend that you have a confidentiality pledge signed by the employees who you're going to grant access to the database to make sure it's called an access agreement. In fact, I think I have put one up in the Box account for y'all, and I'll double check that in a minute. But I want you to have a way, whoever you're going to grant access on behalf of your company, I want to make sure that you have some kind of confidentiality agreement explaining the thorny points of this database. So again, there's a huge landmine there that you can actually avoid. So if you misused information, if they did anything naughty after you gave them access, then you can present this document as your good faith efforts to make sure that they understood not to misuse the data, and it's not your fault, and you shouldn't be subject to being fined. Next, the system is built really on three foundations: query, system, but the CDL. So state of Alabama has a chief CDL officer that judges whether somebody ought to get a CDL. Can they keep their CDL? Has it expired? Should it be revoked? Just like in Massachusetts, they should have revoked the CDL up there. So again, there's access by them as well as by you as the employer. Next, so as we get down to penalty, we're almost finished. As we get down to the penalties, this is why, one, you want to pay attention because it's the right thing to do. Two, is it's going to cost you if you don't. So if you'll see a max penalty per day, so we're back to those landmines, the max penalty per day is $1,100 per violation. That's in a person can be a violation. 11,000 max per total. And so if you don't have a updated policy for your drivers, as of January 6, 2020, you get a regulator coming in there, no updated policy, you're subject to a penalty of $1,100 per day per head. So again, 11,000, that's real money. Knowingly falsification of records, $11,000 penalty. Driver penalty of $3,750 for failing to make their mandated report next. So the regulators that I was with up in Detroit, I asked them the question, is it mandated that they have a policy that actually mentions all the clearinghouse requirements? And they said, totally. So they added a brand new section 12 to the regulations in 382.601 that basically states all the clearinghouse reporting obligations by the employer, and they're all listed. Next. So again, the landmine here is making sure you have a clearinghouse-ready policy, and I say a forms toolkit because I don't see any way for you to administer this without some easily usable, customized forms to help you do that. Everything from refusal forms to actual knowledge forms to all of your response forms. There's actually 4 new forms we put in the pack just for the clearinghouse, everything from driver education and training forms to the confidentiality. And so I just don't see how you do this without an easy way to administer. Next. So let's get your ducks in a row as we close this. So the first thing is, and I would say out of everything, is update your policy, update your policy, update your policy. There's no substitution. It's an easy violation for a regulator to pick up. The internal clearinghouse with protocols and reporting, the protocol and reporting is your form toolkit. The job description and the confidentiality pledge is the document. I'll show you a sample in the toolkit and the box account with that. Service agent agreement. So I'll be helping Todd and his crew with a clearinghouse addendum for their contract. So it'll say exactly what they'll do and what they won't do, and whose responsibility is what. You want to train every one of your employees and supervisors in the clearinghouse. So one of the documents I put in the box account you can look at is a sampling for what that might look like as a way to train yours. Next. So when I'm talking to MROs, SAPs, TPAs, and things like that, I'm giving them the other side of this to consider contractual modifications to do that. Next. So getting registered in your company, one of the things the DOT highly is encouraging is for drivers to register. They then have unfettered access to what's in the database concerning them is a big reason to encourage that. If you're going to get a consent from them, if you get a hit and you don't already have them in the database, they've got to register before you can move forward. So you're going to have to pull them off the road to do that, to designate your third-party administrator like Employment Screening Services, to set up assistance. So I've got multiple employers that we're helping across the country with this task, and it's working out pretty well. And then encourage your drivers to enroll in the system. Next. So there's some links on here. Is there one slide back? Let's see. I don't see it. Okay. So why don't we do it? Let me just give you, I'll include it in the box links. So I'll give you the link to the clearinghouse to register. I'll give you how to request to be put on the email list. So we'll throw that up in the box account as well. I thought I had another slide on this one. So, Megan, have we got any questions today?
We do. And just as a reminder, like Tommy said, we will be sending the presentation as well as links to that toolkit and any other resources that Tommy or Todd feel might be helpful to you via email. You'll receive that to the email address that you use to register for the webinar. If you have an alternate email address, you can contact us directly here at ESS, and our information will be available on the next slide. But we do have a couple of questions. So one that has come in is, how do you report a known violation if it doesn't show up on an MVR check? And the example is a violation that occurred in Tennessee, which is a no-share state.
Okay, great question. Okay, so there's two different databases. Think of the criminal misconduct database is the MVR database. So when you've got a DUI, you've got other things like that. The database of the clearinghouse is a collective database of employers. So think of it if you all were living in the same community, and every week you'd have a meeting and you'd share information about all your drivers. So think about this as a huge national share site concerning driver misconduct, because a refusal is not a criminal act that's going to show up in a motor vehicle check. So they're two totally different databases. It's not going to show up an alcohol positive. That's an employer-driven test. So there's tons of things that will never show up in the MVR that will show up in the clearinghouse database. And the same thing is the clearinghouse criminal misconduct will not show up in the MVR criminal misconduct will not show up in the clearinghouse unless a state regulator decides to put it up there. So they can include those if they wanted to as well. But again, they're really two different purposes. Megan?
Thank you, Tommy. The next question that's come in, we've actually had a couple of questions regarding this, is who does this apply to? Is it only CDL drivers or DOT drivers that tow over 10,000 pounds?
So it's going to cover CDL driver. And let me tell you, I would be expansive within your organization. There's no place that you can buy a query for $1.25. I'm just telling you. You wouldn't. I mean, and so Employment Screening Services you can order queries from, but $1.25 is a cheap query system. And again, it's a different database. it's going to apply to every CDL driver of a commercial motor vehicle. I've encouraged my employers to be expansive. If you consider that you're going to use that person, go ahead and include them in the query list and see what kind of hits you get. You may be surprised. Next.
Okay,
Megan?
So we have time for a couple more questions. One that has come in is, do you recommend running limited queries more frequently than annually?
One of the things I'm waiting to find out if the database is going to do this, if you're an employer that runs a query on a driver, I think the way the database was originally explained to me was that you would then get notice if new information came up on the driver in the database. So again, there's a huge reason why you want to query these drivers on an Excel sheet and put them up there, because then it tags you as the employer with that driver. And again, I can't speak to that 100%, but I think that you will get blowback information even after you do your query. So right now, I just kind of wait and see how the system's actually going to work.
Okay, so another question on queries. If I run an annual limited query and it comes back with a hit, why even bother running the full query? Why not just terminate the driver?
That's a good question. So when you set up your queries, you'll see a key sheet that'll be in the box. It'll ask you to how to list that. Do you list that as a 1, 2, or 3? And if I remember right, the 3 basically automatically runs the full query if you get a hit on the limited. Now, there is no additional charge to run the full query if you got a hit on the limited. It's all covered by the $1.25. So it's a great question, but again, I think you want to make sure that you're going to make a wise decision and not just react based on there's something bad in there. Okay,
so we're running close to time, so I'll ask 2 more questions, but as a reminder, we are capturing the questions that you're submitting through the window, so we'll have somebody reach out to make sure that your question's answered. So a question about a recourse if drivers do not register or will not register. What happens to those drivers?
So if they do not register, you can still run all the queries you need. If they do not register after you get a query hit, you got to take them off the road. So if you get a limited query hit and the driver and you go to the driver and say you got a query, or the way the system works, actually it will automatically, if you put the right box at the end of that line, driver's line, it'll automatically run the full query immediately afterwards when you get a limited query hit. So, yeah, a lot's still gonna come out in the wash about how this thing's gonna work.
Thank you, Tommy. So our last question, if our company has a driver that receives a DUI in their personal vehicle, does that have to be reported to the clearinghouse?
No, great question. No, that does not, but you as the employer can still act on the information. It's just not a violation of the DOT, but you can actually mandate that they go to a SAP. You can put them on a last chance agreement. You can treat it as a violation. You clearly have rights. Let me give you a little weed here. I'm deep weed. Sorry, not marijuana weed. Under 191.11, 49 CFR Part 191.11. So we include this language in your FMCSA policy. We want to give you full and unfettered options on how to deal with that, including mandated disclosure in your policy if they get a DUI after hours. So there's a number of ways you can deal with it in your policy. Federal courts have helped us tremendously give us that information. Megan?
Okay, well, thank you guys so much for your questions. You can keep sending them until we close the broadcast. This is definitely a very popular and confusing topic for our industry. So thank you, Tommy, for shedding some light on what's going to happen and what employers can do to prepare and really be cautious about the clearinghouse and its ever-changing rules and regulations.
Let me add one other thought is
Sure.
within the box, you will find an intake form if you want a policy proposal. And Todd and I've talked, and if you want a policy drafted, if you want to have a direct relationship with our law firm, we can do that directly for your policy support and forms. Or if you want it to work through it in a system where you're still a client of the firm, but it'll be billed through employment screening services. Todd and I are working that out as well. So anyway, but I would just encourage you to get on that like soon. Thank you, Megan.
Thank you, Tommy. And again, you can reach out to either one of us. Our information is available on the screen. We invite you to follow us on social media as well. We'll be publishing lots of updates as more occur and come out before that January 6th date. But we thank you for joining us today and appreciate your interest. Again, Tommy, thank you so much for your insight and wisdom. And you all have a wonderful day. Thank you.